I would like to greet you all. It's a very important day today because we are hosting Professor Dr. Wolfgang Babeck at Ilyas University. Professor Babeck had a distinguished career both in practicing and in teaching and researching law in Europe and outside of its borders. I would like to include Georgia within Europe, and so outside of its borders to mean his very distinguished career in Australia. He published extensively on the question of legal reforms. But what he's very well known, especially in Georgia, it's his work on Georgian legal system. Both practical work, he has been helping the work on Georgian constitution for more than 20 years, and his theoretical works, he has published several books on this matter, and some of them are translated to Georgian language. So we are extremely glad that he's here today and would like to celebrate, so to say, his visit by awarding the honorary doctorate of Ilyas State University, which was done a couple of months ago. The academic council of our university has made this decision. But to fully appreciate the importance of his work, I would like to ask Professor Konstantin Kublashvili to introduce Professor Babeck. Thank you very much.
სასეირნო სიტუაციაში ვართ, როცა მინდა რომ წარმოგიდგინოთ ჩვენი სტუმარი, ატომი ვოლფგანგ ბაბეკი. და ჩემთვის ეს მართლაც ძალიან დიდი პატივია, იმიტომ რომ მე წარმოგიდგენთ ახლა ადამიანს, რომელმაც თქვენ ყველამ უნდა იცოდეთ, რომ ის არის პირველი ადამიანი, რომელმაც საქართველოს 1995 წლის კონსტიტუციის შესახებ ძალიან სერიოზული მონოგრაფია დაწერა. ჩვენი ურთიერთობა და მისი ურთიერთობა საქართველოსთან სწორედ ამით დაიწყო. ეს იყო 1995 წლები და ბატონო დემოკრატიას ეს ძალიან კარგად ახსოვს, როცა ვოლფგანგი მაშინდელ საკონსტიტუციო კომისიასთან მუშაობდა და ძალიან დეტალურად აღწერდა, ინიშნებდა ყველაფერს, რაც მაშინ ხდებოდა საკონსტიტუციო კომისიაში, როგორ მიმდინარეობდა მუშაობა. და ამის შედეგად მან, ასე ვთქვათ, დაწერა წიგნი, რომელიც ჩემი აზრით დღეს უნდა ჩაითვალოს საქართველოს კონსტიტუციის ისტორიული განმარტების ერთადერთ, ასე ვთქვათ, წყაროდ. იმიტომ რომ აქ არის მოცემული ყველაფერი, რაც კი უკავშირდებოდა კონსტიტუციის ცალკეული მუხლების, არა მხოლოდ მთლიანად კონსტიტუციის ცალკეული მუხლების წარმოშობის შექმნის ისტორიას. ამიტომ მისი, ასე ვთქვათ, როლი აი ამ პროცესში არის ძალიან დიდი და მე მინდა აი ახლა დღეს ძალიან დიდი მადლობა უთხრა მას ამისათვის. გარდა ამისა, როგორც ბატონო გიგა მოგახსენა, იგი არის ძალიან ცნობილი იურისტი, როგორც გერმანიაში, ისე ავსტრალიაში და სწორედ ხელმეორედ, როდესაც უკვე როგორც ძალიან ცნობილი იურისტი ჩვენთან ჩამოვიდა, მიიღო მონაწილეობა კონსტიტუციის კიდევ ერთ გადასინჯვაში, ეს გახდა 2010 წელი, როდესაც კიდევ ერთხელ შეიქმნა საკონსტიტუციო კომისია და ერთ-ერთი მთავარი, ვთქვათ, როგორც ეძახით, იურისტი, ექსპერტი, რომელიც ჩვენთან ჩამოვიდა უცხოეთიდან, იყო ვოლფგანგი, რატომ ამასაც ალბათ დიდი ახსნა არ ჭირდება, იმიტომ რომ იგი თავიდანვე, ვთქვათ, დასაწყისშივე იგი ჩართული იყო კონსტიტუციის შექმნის პროცესში და ბუნებრივია ყველაზე კარგად მას ესმოდა ის სიტუაცია, რომელიც ჰქონდა ჩვენ მაშინ და ის განვითარება, რაც განიცადა ჩვენმა სახელმწიფო კონსტიტუციამ ამ წლების განმავლობაში. 2010 წელს იგი იყო ასევე საქართველოს საკონსტიტუციო კომისიის, ასე ვთქვათ, მთავარი სხდომები, რომელიც ჩატარდა ბერლინში, ამ სხდომების წამყვანი და მოდერატორი და ვინც იღებდა მონაწილეობას, აქ არის რამდენიმე ადამიანი ასეთი, ძალიან კარგად ახსოვს ბატონი ვოლფგანგის აი ეს როლი, რომელიც მან ითამაშა საბოლოოდ იმ ცვლილებების დახვეწაში, რაც მაშინ განხორციელდა საქართველოს კონსტიტუციაში. ასე რომ თქვენს წინაშე არის ფაქტობრივად ადამიანი, რომელიც ჩვენი კონსტიტუციის არსებობის 20 წლის მანძილზე მუდმივად, ასე ვთქვათ, მასთან ერთად, ასე ვთქვათ, დადის და ადევნებს ფალკუს და თავის ძალიან მნიშვნელოვან შენიშვნებს, რეკომენდაციებს გვაძლევს. მან ისევე როგორც ქართველმა ავტორებმა ამ კონსტიტუციისა, მათ შორის ბატონი ავტორი არის ერთ-ერთი მათგანი, ასევე ძალიან დეტალურად იცის ის ყველაფერი, რაც მოხდა და როგორ ვითარდებოდა ჩვენი ქვეყანა და ჩვენი კონსტიტუცია ამ წლების განმავლობაში. ასე რომ კიდევ ერთხელ მე ყველას მინდა გითხრათ, რომ ასეთი ისტორიული პიროვნება ფაქტობრივად ძალიან იშვიათად გვიქნება ჩვენთან, უცხოელი, რომელმაც საქართველოს კონსტიტუციის შესახებ ძალიან ბევრი დეტალი იცის და ძალიან დიდი მადლობა მას იმისათვის, რომ ეს ყველაფერი გააკეთა და მისი, ასე ვთქვათ, მოღვაწეობა ჩვენი უნივერსიტეტის მხრიდან სწორედ იმით დაფასდა, რაც ბატონმა გიგამ მოგახსენებდა და ამის ცერემონიალს, ასე ვთქვათ, დღეს ვიხილავ. მე არ მინდა მოვლენებს გავუსწრო წინ. აი ეს მინდოდა მეთქვა, მე კიდევ ერთხელ მადლობა მინდა უთხრა ვოლფგანგს. დარწმუნებული ვარ, იგი მომავალშიც იქნება, ასე ვთქვათ, ჩვენი ქვეყნის და ჩვენი უნივერსიტეტის, ასე ვთქვათ, მხარდამჭერი, აი ამ დღევანდელი დღის შემდეგ და ეს ძალიან დიდი, ასე ვთქვათ, პარტივი არის ნამდვილად ჩვენთვის და ჩვენს უნივერსიტეტს იქ და სამართლის სკოლას განსაკუთრებით ძალიან დიდ დახმარებას გაუწევს, დარწმუნებული ვარ. აქვე მინდა ასევე გითხრათ, რომ როგორც ვახსენე, წელს 20 წელი სრულდება საქართველოს კონსტიტუციის მიღებიდან. ეს ყველა მიცის და სავარაუდოდ დაგეგმილი იქნება სხვადასხვა ღონისძიებები, მე ესე ვფიქრობ, თუმცა რაც უკვე სამართლის სკოლამ გააკეთა, ეს არის ის, რომ 20 წლის თავთან დაკავშირებით პირველ რიგში დაიწყო საჯარო ლექციების, ასე ვთქვათ, კითხვა ჩვენთან უნივერსიტეტში, თუმცა ასევე რამდენიმე სხვა ნაბიჯიც იქნება, რომელსაც ჩვენ განვახორციელებთ და მე ვფიქრობ, რომ ნამდვილად სწორია, რომ ამ 20 წლის ისტორია გავიხსენოთ, აღნიშნოთ და იმისათვის, რომ შემდგომში უფრო განვავითაროთ ჩვენი კონსტიტუცია, გასული დასკვნებიც გამოვიტანოთ ამ 20 წლიდან და ამას ილიას უნივერსიტეტის სამართლის სკოლა იმედი მაქვს წარმატებით განახორციელებს. კიდევ ერთხელ დიდი მადლობა და მე ძალიან თქვენთან ერთად ძალიან დიდი ინტერესით გაველოდები ვოლფგანგის საჯარო ლექციას. მადლობა. დიდი მადლობა.
Now we'll ask Rasakuri Bozat.
Besaunet ბატონებო, მე საგანგებოდ არ ვებზადებოდი ამ გამოსვლისათვის, მაგრამ ჩემი მეგობრის და საქართველოს მეგობრის ნახვა ასეთი სურვილი გამიჩნდა რამე. უნდა მოგახსენოთ, რომ ვოლფგანგი მე ვფიქრობ კონსტიტუციური ისტორიის გამოყოფილი ნაწილი. ისეთი სტანდარტიზება მექნება ზოგჯერ 21 წლის კონსტიტუციის შემუშავებაში ციხე და მონაწილეობა. მან ძალიან კარგად იცის ქართული ისტორია ზოგადად და დამოუკიდებელი საქართველოს ჩამოყალიბების პირველ საერთოდ საქართველოში იმყოფებოდა. გახსოვთ თქვენ, იყო ჯავახიშვილის უნივერსიტეტის სტაჟიორი, ხო? მე ასე რეკომენდოდი მაშინ მის თანამდებობას და მისი მეგობრები იყვნენ ლადო ჯანკოვია, დათო მოსოფაშვილი, ბატონი კოხე, და მეც ვიყავ მისი მეგობარი და მე ვფიქრობ, რომ დაგჭირ კიდევაც მეგობრებად. ასევე დაგჭირ მეგობრებად. მე მინდა აღნიშნო არა მხოლოდ მისი მონაწილეობა კონსტიტუციურ სამართალს შემოქმედებაში, განსაკუთრებით ამის თაობაზე ვიწანა უკვე, არამედ მისი საგანმანათლებლო საქმიანობას, რომელსაც იგი მუდმივად ახორციელებს ჩვენთან. გარდა ამისა, მას მისი აქტიური მონაწილეობით ინიციატივით გიზის ფინანსური მხარდაჭერით განახორციელებს საკმაოდ დიდი კვლევები განახორციელებს რომელიც ეძღვნებოდა საქართველოში კონსტიტუციური განვითარების რაღაც ეტაპს და დღევანდელ კონსტიტუციურ იმიჯს საქართველოში. ამიტომ მე მხარს ვუჭერ დიდმადლობას მოვახსენებ ილიას უნივერსიტეტს, რომ დააფასა მისი ამაგი საქართველოს კონსტიტუციური განვითარებაში და წარმატება უსურვო მას უნივერსიტეტს და უნივერსიტეტში ამ 20 წლისთან დაკავშირებით რაიმე ღონისძიება ტარდება, მე მგონი მისი გახსნა ვოლფგანგს ნამდვილად წაახდება და დაამშვენებს კიდევაც მის გახსნას. მადლობა.
So it's time for a lecture, the relevant differences between the common and civil law systems and the lessons to be learned for Georgia. I think it's a very relevant and very interesting topic. Please.
Thank you very much. Before I start with the lecture, and on request, this is not about the Georgian constitution, but is about a different topic, also very relevant to Georgia. I would also like to take the opportunity to acknowledge some of the guests here or the contributors why I'm here. I first and foremost like to acknowledge the presence of Professor Aftandiye-Demirtashvili, my teacher from 1991, it's as long as it dates back, together with two other teachers, which were Tedo Minidze and Ota Damkrevidze, and as well supported at that time by Datu Usupashvili and Gia Getzadze. I also want to acknowledge the presence of the Dean, Professor Chokoraya, of the Rector, Professor Zedaniam, and finally, I'm very thankful also to you, Professor Kublashvili, that you said these words of thanks, because I'm so grateful to you, because many years ago you, as Deputy Minister of Justice, translated my first works on the Georgian Constitution, which I thought was amazing, and I'm very thankful for that. Now let's go into medias res and talk a little bit about the differences between the common and civil law system. And if there's a problem with understanding English, etc., there's at least two more headphones here, or you can also signal to me if it's too fast or too slow, or if you can't follow, then give me a sign so we can interrupt and catch up. I hope there will be a bit of time for questions later on, but let's see how we progress.
Just a small remark, headphones are also in the hall, so if somebody...
So, this very morning I had a long chat to Dr. Shalva Papuashvili, who is also here and has been a very good friend for many years, and I picked up this book from the library of GIZ, which is by René David. Many of you might know this book, and it's called Introduction into the Great Legal System of the Present. And interestingly, when you then look at the legal system that Mr. David proposes, he talks about a system he calls the Germanic Roman legal system, which I will refer to as the continental European law system. Of course, the common law system, but there's one other system which he mentioned. Maybe you can take a wild guess, but what he is referring to is the Soviet legal system. So interestingly, is there a Soviet, or has there been a Soviet legal system or not? Many of my colleagues here talking about Eastern European law, they say no, that's rubbish. There has never been any Soviet legal system. This is all civil law system. I tend to disagree, however, because I think that the Soviet law, to which Professor Dimitrashvili introduced me to the law of the Georgian SSR back in '91, had a lot of idiosyncrasies, was very special in a lot of ways. And a lot of things we still need today, so we need to know about the history of that system to understand the other legal systems properly as well. For example, there was funny things about it. The Soviet legal system always was a revolutionary system. It never arrived at a point, but it was always developing. He was talking about a collective society rather than individual society. So I remember this funny incident where, as a young lawyer, I was asked to fly to London in the morning, have a director of a Georgian company sign and come back with his signature to Hamburg at noon. I have never done such a silly trip. But what was the reason that I had to fly from Berlin to London and come back to Hamburg? The reason was that the institution we were acting for had so many directors. And one of the directors' visa expired for the UK, so he went to the airport to fly out. But we still needed his passport, his signature, to comply with the requirement that every little director had to sign on this deed. A very special Soviet law element that many people have to sign, that you share responsibility. Let me give you another example. When in 1991 or 1992, I think it was, I wanted to buy a flight ticket to go to Moscow to relax a little bit from the entertaining lectures, and I was standing at the airline office of Aeroflot at that time, and I stood there and I waited again, and the line just didn't diminish. So when I then looked a little bit closer, I noticed that people were passing around me and queue jumping or getting ahead of me in the line. Now other people were upset by that as well, and a lady came by and she wrote everyone a number in his palm, in his hand. Number 1, 2, 3, 4, 5. To say, okay, well, this is now the rule of how we are progressing. So she was establishing a new rule. But I noticed that even though I had this number now, I still did not proceed well, because there were some other special people who were passing the line, and at an entrance nearby were knocking at the door and getting special permit to buy their ticket on the side. So what are the lessons to learn out of that? Well, the first one is there's a legal history, which has been governing this country. There's also a difference of informal or unwritten law to the statutes we otherwise see in the codexes, in our legislation. And if we do comparative law, it is very important to understand what is the real practice of law, and not just what is in the books. Yeah? So, lessons to learn from Georgia from this. Number one, many of you have experienced a dramatically changing legal system over the past 15, 20 years. You therefore have a natural interest and understanding in other legal systems, because you have experienced those changes. Lesson number 2. Many of you have experienced firsthand the difference between unwritten law and written law. You are therefore particularly qualified as observers and commentators. You have a particular antenna in respect to legal systems. Let us look now at the few points I'm going to talk you through. Why and how are legal systems different? We talked a little bit about that. Continental and common law. And we'll look specifically at 3 elements of law. Contract law, company law, and conflict resolution. Contract law, company law, conflict resolution. Let's start with why and how are legal systems different. Let me tell you a little story. And when I stroll down Marketplace in Sydney, there are these funny people running around with big wigs. They are called barristers. Something we don't know in this country, something we don't know in continental Europe. And it's a rather obvious difference. There are other differences. For example, if I have been sitting with a client from Australia in a transaction in Germany. Now the transaction involved the purchase of shares in a company. How did this occur? To the big surprise of my Australian client. We were sitting in a notary's office, and the notary read out for hours and hours the contract in German. So my Australian client was sitting there listening to all this German, didn't understand anything, and he wondered, why does that contract have to be read out? Very obvious difference. But these are the obvious differences. There are, however, many small tiny differences which are important to know to really understand the legal system properly. Let me give you a cultural example. A few years ago, I read in the newspaper that a German had dogged someone to the police. So I'm not sure whether you know the word dog, but he had basically reported someone to the police because that person had illegally parked his vehicle in a street where there is no parking allowed. Now you would say, well, that's nothing special, you know. This happens every day, you know, the parking, people get upset, etc. But the funny thing about this was that the person accused of this administrative defect was the Pope. So he accused the Pope of parking his papamobile in the wrong space. Yeah? And the police then had to investigate and do a formal procedure, and they then happily came up with, you know, a good explanation that this he was excused or whatever. But I would claim that something as stupid as this can only happen in Germany, you know, because they have a very formal legal tradition. They have, you know, people who think, you know, that everybody needs to comply with the law to the very last syllable, etc. So there are a lot of cultural elements which also influence our language. Continental and common law. If you have a look, all the countries marked in blue are somehow attached to common law. Some of them are, you know, the cornerstone of common law, like the UK. Others have adopted and changed it in not too many fashions, like New Zealand, Australia, India. Some have done so to a larger degree, the US. But interestingly, if a colleague of mine is qualified in Australia, he can easily work in England, in India, in Malaysia, in Hong Kong, in South Africa. Because the core of the system, what is called common law. So common law is also called everything which is not codified in the Anglo-Saxon legal system. Two connotations. One is the system itself, and the other thing is the non-codified law. Is pretty much the same. A lot of things are of course different. For example, labor law. Every country has their own labor regulations. Very topical, constitutional law, for example. But a lot of the core is the same. And so there is maybe a big advantage in being a common law lawyer. At the same time, these common law lawyers usually know nothing about civil law. And that is such a pity, because I think you need to understand a little bit about both systems to properly understand your own system and to give good advice. And people, perhaps of you who are involved in arbitration, in international arbitration, know that, because international arbitration is often a point where common and civil law overlap, where you have an arbiter from Brazil and one from, say, Malaysia, and they still have to come to a joint agreement. Now, our system, of course, when I talk about Georgia, derives from the Roman system. Justinian, which has been later on adopted in many European countries, and has then also been expanded basically all over the world. So all the grey countries are by now civil law countries, continental European law countries. I move on and look at some of the differences. One of the differences is legislation. Civil law countries understand law always as a science. That has not been the tradition in England and Wales. In England and Wales, law was a practical element. In England and Wales, the stars of the legal professions are not the professors as here. It is the Chief Justice, it is the Justice, the Judge, etc. They are the leaders of the opinion. Because it had a practical approach, it was laws, decision handed down by the king or some of his allies. And so it's a collection of decisions. It is what we call case law. Now, much of that case law, of course, has changed over time, because England and Wales, particularly becoming a member of the EU, but also through other influences, has passed a lot of legislation. And a lot of the continental European countries have had a lot of judges interpret their codes. For example, the Code Civil in France, 1804. How many judges have ruled on that? If you look at the German, the BGB, the Civil Code, 1900. So many changes, so many interpretations by experts. And I've heard today that the GIZ is accompanying a large project with the commentary of the second commentary, I think it is, to the ZGB. We have had commentaries on the human rights part of the Constitution. So you know about all the commentaries are basically a collection of case law. So of course we have lots of case law in civil law countries, and we also have lots of legislation in common law countries. So it's not so easy to say, oh, this is that, or it's not black and white. Now let's look at legislation. Legislation is usually a bit different. The continental European approach has been to systemize the law. So they're saying every aspect of the law is captured by one system. So if I have one problem, I know exactly that's where it belongs, or that's where it is. And to do that, you have to systematize your legal system. You have a structure, you have codexes which are planned, which are academic work. If you look, for example, at the German BGB, civil code, German lawyers need at least 3 years to understand it. It's a highly complex element. And what is one of the problems with this? It has an initial, a general part. So it has a general part and has lots of specific parts. Common law legislation usually is different. It has no general part. It has no abstract part. That means it is much more voluminous. So, for example, what you see here is the Australian corporate legislation. So everything about, joint stock companies, limited liabilities, etc. Altogether, around 4,000 pages. The law you currently have on foot in Georgia has about 70 paragraphs. That's all. So what a huge difference. Lesson to learn for Georgia, I think you have to find your own way. What you would like to is you have to have a readable document so that users who are not specialists, who are not lawyers, can understand the legislation. And on the other hand, you want to have something which fits in the system, so it has some intelligence, which may, be structured in a way that there is no loophole. And finding that compromise is a difficult task. Another lecture out of that, another lesson is, you have to work with experts from different legal systems, because usually people only know their own legal system, and then it's difficult to compare them, so you have to do that job yourself. Let's move on and have a little look at contract law. I want to cover 5 questions briefly. First one is, isn't contract law all the same? Second, why are common law agreements so voluminous? Why do we need a notary? What are specific contracts, and where to find the purchase price? We are all purchasing things. We are all offering services, etc. All across the world. We have joint agreements. For example, the Vienna Convention on the sale of goods. Isn't it all the same? What's the difference? Why is there, a Swiss law, a German law, a French law, an Australian law, English law? Isn't that all the same? And you would think it should be. But I claim there are significant differences. And what are they? One of them is that the civil law system uses a notary public. Now, the most important contracts, for example, any testimony in family law, anything related to real estate, where you have big investments, big personal investments, inheritance law, and also company law. If you want to transfer a share of a limited liability, you always need to involve a notary public. Not so in a common law country. So the continental European system has decided to spend a lot of time in preparation of its documentation into the decision-making process of how an agreement will look like. That, of course, is an intensive task. It costs money, it costs time, it leads also to the fact that agreements are entered into only after long consideration. The common law approach is much more prompt and quick. You just go to a solicitor, a lawyer, you have your contract, you shake hands, you go on. Yeah? So there is a different system. You may have to tidy up things later on when you notice, oh, here's a problem, there's a problem, etc. But the access of it, the readiness, the quickness to contract conclusion is arguably quicker in a common law country. Now, another difference is the question, why are the contracts in common law so voluminous? Anybody has an idea? So I'll show you a contract in a minute, which is the sale of some shares in a company. It's a real-life contract, which has 33 pages. And that's the short version. A common law contract. The same contract in civil law, 3 pages. Why are you have heard about these crazy contracts? Why do you think are they so long? Any idea? Because, there's several reasons, but one of the main reasons is because the legal system of England and Wales, of Australia, of all these common law countries, often have not codified contract law. They've codified all sorts of things, employment law, blah, 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 but they have not codified contract law. I mean, we know England has not even codified its constitution. But Australia has nothing, simply nothing. England has some. There's an act of sale of goods, unfair contracts, services, etc. But all these are rudimentary, little things. So if I'm now a solicitor, I am a solicitor, and I have to advise my client of how best to protect him or her, I have to write everything which otherwise is in codified law into the contract, because I have to exclude that in 1859 or 1878 some court ruling says something different about a certain aspect of my contract. So in the contract you try to exclude all the common law or the uncodified law which you don't want to have applied. That's why these contracts are so prolonged. Now, let's jump across that and look at a real-life example of a common law contract. This common law contract is an agreement for sale of shares. So, one group of students is selling shares to a German investor. The only thing I would like to know from you is, what is the purchase price for those shares? Any ideas where you would look for the purchase price?
Price tag. Price tag.
A price tag.
Just kidding.
Okay. Price tag, yes. Well, let's scroll through the agreement and see whether we find a price tag. Yeah? So you see here it starts off with definitions and interpretations. Then we have, what is number 2? Condition precedence, so what needs to be done for the contract to come in force. And then we have sale of shares. Okay, sale of shares, that sounds great. Let's look at the sale of shares a little bit closer. That's too much, too close. Here we go. I read it out for you. Number 3.1. The vendors agree to sell to purchaser, and purchaser agrees to buy from the vendors for the purchase price, the sale shares including all the rights, title, blah, blah. So it says for the purchase price. Now what is it? Where's the number? Is it $1 million, 2 million, 100,000, 10? What is the purchase price? Anybody can give me an idea? Where do I find it?
On the contract day when you shake the hands, folks.
On the contract day when I find it. Yes, that's right, but I'm looking for some evidence in this contract.
Transaction, bank transaction.
Bank transaction, good idea. I want something from the documents. Where can I find it in the documents? 33 pages. Where do I look? Now there is something very special in this little paragraph. And I'll try to bring it up a little bit closer still. That I would like you to be aware. And my understanding is that this is usually not taught in schools. Although it is so essential to understand common law. If you don't know that, you're lost. So if you look through this paragraph, and you see in the second line, for the purchase price, is there anything which is special? The secret is, if you look at it, the purchase price is written in capital letters, in big letters with big P's. In English language, like in the Georgian language, you usually don't use capital letters, different to the Germans. The Germans have a real problem with that. They don't get it. Huh? So you will see that in this paragraph, a lot of words are written in capital letters. The vendors, the purchaser, the share sale, blah, 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 the encumbrance, all in capital letters. And all those words in capital letters are codified. What does it mean? They are not just the words which they stand there, but they are somewhere defined in the contract. And where are they defined? That's right, in the definition section. So let's go back to the definition section. This was up front. It's a lengthy section here, but luckily it's in the alphabetical order. Yeah. And then we'll see, here it says, the purchase price. Oh, here we go, the purchase price. Now what is it? The purchase price means, subject to clause 8, the aggregate of the share sale price, the second payment, and the side payment. Oh my God. No number again. Where is the number? Where is the purchase price? Now I have to look for the share sale price. Let's scroll down. The share share price means the per share sale price referred to in item 6 of Schedule 1. Now where is Schedule 1? What do you think? That's right, it's at the very end of the contract. So let's scroll down to the schedule. Well, here. This is the waiver. Schedule 3. This is Schedule 2. And here is Schedule 1. And here we see some numbers. The sales share price is 2.88 million. The second payment is 875,000. So there is our answer. So what is the lesson to take home as a civil law trained lawyer in Georgia? Number one, enjoy short contracts whilst you can. Number two, watch capital letters. And number three, be careful, or number three, and pay attention to the definitions and the schedules. Usually we think this is the fine print, this is where the technical stuff is. We're not interested in it. But in common law contracts, this is often the most valuable and interesting part. Now, I often see contracts in common law which don't make sense because they use different definitions. Because people have used, where are we here? Templates, text templates from one document and imported them into another document. But you see in a contract where everything is codified, where you jump from island to island, from capital letter to capital letter, this is difficult and create confusion. So my colleagues often use navigation here and say, okay, I want to see everything where is purchase price. Yeah, and then they get marked where these elements come up. So this is good editing of contracts. So the lesson to take home from that is also that we need to be very careful when mixing the different systems. And that applies particularly for legislation. You cannot take a law which is made under civil law and borrow a number of elements from common law, or vice versa. You cannot take a common law legislation and say, okay, well, we'll introduce some elements from the civil law. If you do that, you need to be very attentive that the legal philosophy behind it fits it. Okay, let's quickly move to the question of company law. There we are, here. Company law is one of my favorites. Why is that? Because company law has a lot to do with the rules of governance. And people ask me, Wolfgang, why is it that you practice constitutional and company law? And I say, well, because it's about the rules of the game. Whether you do that, you know, in a governmental system or whether you do that in a company system. Everybody has to obey rules and you have to agree on rules initially. Now, again, the market philosophy in the two systems is very different. In continental European companies, you often have family companies. Family companies who have a limited number of shareholders, who are investing money and leaving it in the company and reinvesting that money. You have a tradition where the company takes great care of their employees, where the employees are being looked after for a long period of time, where you have loyalty. Often, somebody enters into a company and stays there for the rest of their life. I spoke to a friend recently who is responsible for trade unions, international trade unions at VW, at Volkswagen in Boston. And he told me that he had the Minister of Employment, State Secretary of Employment of the US visiting. And he said he was a very good guy because he was ready to listen. He spent hours with them and tried to learn, tried to understand. And they told him what the word Beruf means. Profession, you know, dedicated to it. And he asked, what sort of turnover do you have? And the turnover at VW is absolutely minimal, because people are basically they're employed for lunch. That of course has its downside. It has a lot of inflexibility. The labor laws are so strong that you don't get rid of the people. You can't move that quickly, etc. You have, and we come to that in a moment, you have employee participation in decision making. So this is, but the main element about what you have to take home about a company in a civil law system is that the company of itself is of value. So the existence of the company. So the company means its shareholders, its staff, its management, its stakeholders, so customers or related entities they interact with, and lastly, the company itself. This is, and there are lots of laws to protect the company. In the Anglo-Saxon system, which is, say, maybe a bit more commercially driven, it's different. The main element there is the shareholder value. The Anglo-Saxons say, we own the company, we are the boss, we fire whom we don't like, we decide where the money goes, and we want rules to implement it. And that is another approach, you know, it's not good, it's not bad, it's simply different. But we have to understand that as a background to understand why rules around companies are different in these countries. So number 2, rules of establishment. Rules of establishment, usually very easy. I can set up a company in Australia in one day. If I have to try to do that in France, in Germany, in Indonesia, etc., it takes a very long time. You have a notary involved, etc. And again, you want to have a precautionary system. Now, a lot of the continental European system had to reform because there was a competition about establishment. So in a lot of the countries, you can now set up companies on the cheap and quick as well. But there are other rules about establishment. So, for example, if you have in certain continental European countries the law to inform your shareholders if a minimum requirement is capital is breached. You don't have that at all in common law. You have the problem that the statutes in civil law countries are often spelled out to the minute. And why is that? Because all the statutes were developed at around 1860, 1870, 1880, when there was the Industrial Revolution in Europe. And a lot of those codexes have never been changed since. That means you have so much case law on them, which needs to be considered. So in that case, the civil law system is not optimal, is not up to date. Governance, let me just quickly mention that governance in the civil law countries, you often have a supervisory board. You have a consensus-driven society. You have people, you have several board members. They all have equal votes. There's long discussion. Yes, do we do that? We want to come to an agreement. We want to be on the same page, etc. Common law system, much more hierarchical. Much more, one tells what has to be done and that is implemented. Much more quick to the action. Common law system vests a lot more competences in the board than at shareholder level. So the shareholder, which you see here in green, for example, in GmbH, in a limited company, has a lot of powers in a civil law system, not so much in a common law system. My clients are surprised that a director in Australia can define his or her own salary, that he can appoint other directors as he likes to be approved later, that he can issue new shares. These are all things which you would never have in a civil law context. Let me come to conflict resolution. Conflict resolution also, as we know it, under litigation. The way, how can you deal with a problem? I picked this because I think it is a fundamentally different approach which has impacts not only on the legal system but on the way the society is currently developed. And I'll try to explain to you why. There has been a study made to compare the Oberlandesgericht Stuttgart, so the higher regional court of Stuttgart, and the Supreme Court of New South Wales, which is the highest court in one of the states, large states in Australia. So they are about even ranking, also in population. Now, if you look at the elements, duration, Australia 4 times as long. The documents which you needed to run the lawsuit, in Stuttgart 30 documents, in Australia 5 to 20,000 documents. The judgment writing, how much time did the judge take to write the verdict, the judgment? In Stuttgart, on average, per verdict, 6 hours. In Australia, 37 hours. In a moment, we'll come to why. Judgments. How many judgments were actually rendered? So, in a lot of cases, the parties agree on a settlement before it comes to a judgment. In Stuttgart, 35% of the conflicts were decided by judgment. In Australia, only 6%. And now we come to the main important point, the cost. In Stuttgart, the average cost was $17,000. In New South Wales, $150,000 on average per litigation. You know a lot about injunction, I'm sure. So injunction where you will get quick decisions, ad hoc decisions from the court to stop something, to have an intermediate measure. In Stuttgart, it takes $5,000 and about 3 days to get an injunction. In New South Wales, it takes $50,000 to $80,000 and about 3 months to get an injunction. Now these differences, as you can see, they are massive. And there is a TV show in the US which talks about litigation. And the content of the TV show is not who wins or doesn't win the litigation. The content in the TV show is only about avoiding the litigation. How can I stay out of litigation? Because litigation in common law countries is nowadays so expensive that people try everything to stay out of this litigation. And what are some means to stay out of it? First of all, risk aversion. You try not to do things which are risky. It's not good for business. Secondly, compliance. You have people sign everything, you put out signs, don't do this, don't do that, don't drink hot coffee, you could spill on could burn your stomach, all these silly things which you might have heard about. where there have been judgments rendered. So everywhere in common law countries, you now see over-compliance, and thirdly, of course, a compromise of civil rights. So if everything is forbidden, you are compromised in what you can do, in your liberties. And this is a tendency which is coming from the US, going to England, Australia, where a lot of these countries now have to fight. And I say that is because the litigation system is kaput, is not working. Let's look why. Why that is. The English litigation system is all about identifying the truth. The element that is behind it is the judge is not so much a decider. The judge is a coordinator, is a moderator between the two different parties. So the idea is, if we discover jointly so much history about the case, so much evidence about the case, so much facts about the case, then the truth will be obvious and the decision is easy. So the Anglo-Saxon system has what is called a discovery. What does it mean, discovery? Discovery means that everything which is relevant to the case needs to be presented. Civil law system says, no. Only the documents that I have are needed, can be brought to win the case. So for example, Professor Cote and I have a contract. And he bought this flag from me, or let's say I bought the flag from him, but I never paid him. So I've got the flag, but he lost the contract. What can he do? He can go to court, but he has no contract, so he'll likely lose the case. Not so in a common law country. In a common law country, he could come to me and say, you have to produce your copy of the contract, and I would have to give that to the judge. And then we would have a decision. Now, principally, that's a good idea, but discovery nowadays means, at least for my clients, that there is an order, please copy everything, every communication between 1999 and 2007. And 3 secretaries have to work for 1 month to copy, thousands of pages and thousands of folders to comply with that order. I have been involved personally in cases with 100 or 200,000 documents discovered. What pages? Documents. As you can imagine, discovery gets ever more voluminous because emails, communication, metadata, all of that is growing every day. We all know this, 20 years ago we wrote 1 letter. How many emails do we write today? All this is captured. And often one single judge has to read it. A Supreme Court judge in Brisbane told me, this is a few years ago, on the eve of the hearing, I got the file. It contained 600,000 pages. However, only in GIF format. So I couldn't even search them. It is absurd. Not one person can digest it. And now comes the second problem. The judge in the common law system very often sees all the documents, all the evidence, all that material only on the first day in court. Why is that? How stupid is that? How can he possibly come to a judgment in that time frame? Yes. Now there's an interesting background to that, and that is that in common law, the common law system, the civil law litigation, you know, I want something from another person or two individuals, two companies, was originally a jury system. Meaning, when you step into the courtroom, nobody could have been informed previously. So they had to be, all evidence had to be tabled afresh, everybody had to listen to the same evidence and come to a judgment. And this is also why still nowadays, the judges often are not informed of the case before they step into the courtroom. And everything has to be tabled. The barrister is starting from Adam and Eve and telling about this case for hours and hours, cross-examining people. So the jury trial has been abolished, but not the system. We had some the Wolf reforms, Lord Wolf in England were good. They've put a lot of forms into the process that has helped. But in other countries we don't have them. And a lot of people, in particularly the judges, they're compromised. The law firms, the clients, they can put on other people to support them, but the judges, they usually have only one or two assistants. How can they digest it? So, understanding the big differences in litigation is very important to understand the legal systems. What is the lesson to take home for Georgia from that? I believe the lesson is, if you speak to your clients, if you can agree on a forum, so the place where the jurisdiction takes place, in a civil law country, I would always recommend to do it. So have the forum in Georgia, have it in Zurich, in Germany, in France, wherever, in Spain. If you cannot agree to that, then go for arbitration. And if that doesn't work, you're stuck with the common law system. However, your advice will of course depend on whom you're acting for. If you're acting for a party, a strong party who doesn't want litigation and wants to make it difficult to litigate, you might advise your client to go for a common law forum and therefore discourage the other side to undertake any litigation. If we look back on the differences between the legal systems, I would say the legal systems obviously often come to similar solutions. You know, if you have a commercial deal, it doesn't matter whether you're in Spain, Georgia, let's say in Japan, you will eventually want to have a fair outcome. And in some way or the other, the legal systems arrive at that outcome. The way they get there is, however, different. And the more you know about those differences and know about the structural elements in these systems, the better you will be acting as a lawyer or as a judge or as a professor. And that's why I can encourage you to participate in that civil and common law dialogue, to get engaged with people from other universities, with other practitioners, with other academics, to exchange views, to deepen the understanding of the other legal system. Both the two professors here, but also Batono Gigga, have told me that they strongly believe in international exchange and international discourse. And I certainly also believe that this is vital for good professionals in today's globalized world to strive and to be successful. So thank you very much.
Thank you, Professor Babeck, for this very clear, deep, multifaceted, entertaining, and inspirational lecture. And now it's time for the questions from the audience. კითხვების დრო ან კომენტარების და ძალიან ისეთ მოგიწოდეთ რომ პროფესორ ბაბეკს დაუსვათ ეს მქონე რომ ეს შეიძლება გამოიჩინოთ.
Law School, Ilyas University. Thank you very much for your presentation. It was indeed very interesting to listen to you having these two perspectives from German law and now on the common law, because debate in this country has been always very dense and very intense on which path we should choose. And in public law, we have largely decided, I guess, to follow common law traditions of adversarial process and criminal justice, and now trying to introduce more freedoms for the courts to interpret the laws, which is, I guess, now a tendency in a continental system as well. But in civil law, it has been a debate. Should we stay with the civil code that we copied from Germany, or should we continue elaborating the system to make it more business friendly, as many see current civil code not very business friendly in terms of not being very flexible and dynamic. So what do you think, trying to now criticize the continental tradition of the civil law? Is it good for business to practice continental tradition? Is it better? Or let's say, would business prefer to be with the common law traditions? Thank you.
No, I think we can answer the issue. That's fine.
Georgi, thank you very much for this very competent question, which is indeed a very difficult one. Let me say a few things about the notary public, because I think the notary public plays a key role in this area. Professor Knieper, whom you might know, Wolf Knieper, who has been active in Georgia for many years and was also involved in drafting the civil code. He has written a book about the economy of the notary. And in this book, he makes a financial analysis of whether it is viable to have a notary, whether it pays off to have a notary or not. He concludes that there is no question to have a notary, and that the financial benefits are enormous. One of the conclusions he draws is that, in particular, the subprime crisis in the US would never have happened to such a dimension if the US had a notary public system, because all the collateral debt obligations and the non-recourse loans, etc., would have been far better explained to the people, and would have certainly led to more rigid decisions also by the banks to hand out loans. I would tend to agree with Wolf Knieper. However, I have experienced the benefits of the absence of a notary public in the commercial law. And I think that the way that that the management of the company is regulated today in many civil law countries is too complicated, is too formalistic. There's another tradition behind it. For example, you want to search for a company in the US or in England, which is not a private limited, but for example is a partnership, you will not find it. The partnerships are not vested in the company register, which of course opens a lot of avenues for abuse. You have stronger laws in the Anglo-Saxon area about the liability of directors. You have crazy things like directors, for example, telling me that they destroy all their papers after every board meeting because they don't want all these papers to be discovered. They only want to have the papers, the minutes of the company in the documentation. There's a lot of emphasis on compliance because the law or the system invites often to an abuse because it's not as transparent. It protects people who want to misuse it. However, I believe that it is possible to stick with the civil law system and introduce a lot of reforms which make the civil law system much more flexible and much more easy to use. I'm a strong believer in continuity in legislation because I think that the public needs to endorse legislation, it needs to use legislation, it needs to trust legislation. And if you change legislation too often, you create confusion. You also create distrust. You also, you compromise the rule of law. People will say, well, today the rule is X, and tomorrow another government is coming and saying it's Y. And that is not good. So even if you have a law which may have some defects, which doesn't function so well, you should see whether you can keep the core of the law and then implement little changes to ameliorate. For example, in the company law, the Anglo-Saxon system has based a lot on forms. So let's say I want to change a director in the company. Let's say I want to change the name of the company. I simply fill out a form, have a director sign, send it to the regulatory office, and that's it. I don't need advice from a solicitor. I don't need to involve a notary public. I can download this form from the internet. So this is one measure, to eradicate some of the bureaucracy existing within the civil law system. But that would be my preferred path to continue with existing legislation and work on that basis and to have a good result. However, I had an interesting chat this morning with Shalva Papuashvili, and that revealed that the law and entrepreneurs, which my colleague Hartmut Fromm back then drafted, has over time been amended again and again and again and again. And I fear that a lot of these changes also came from common law and don't fit in. And there is already a confusion now, what is the law and how does it work and what the practice about it. So if that is the case, I don't know, I'm too far away. And then you may also say, okay, we give it a fresh start. But this is a discussion which should be going on, and I also encourage the law faculty here to think about maybe introducing a seminar series for directors of companies to train them in compliance, in decision making, in risk component, in legal components, to become better directors. Because I think that goes hand in hand, having good legislation and a good implementation of that legislation. Hope that answered your question.
So, any other questions or comments? Swana, შეკითხვები ან კომენტარები? ამიგონია, მომწვეულ ლექცია და მომწვეულ ასეთი იყო შეკითხვაზე. So I think we have...
Let me maybe make one more comment, because some people have, before the lecture, asked me about the time in 1991 and some of the constitutional issues. For those of you who also, I must say, understand German, I have written a book which is called Der Georgische Knoten, where I have reflected on some of the impressions and experiences I have discovered here in Georgia. So this is a non-legal book. It's about the culture, my personal views, and I think that this book is available at Prospero Books soon, or you can ask me, and I can see how we can organize a copy for you if you're interested in this more personal side of my long experience with Georgia.
So, thank you very much once again. And in order to
really appreciate Professor Babeck's contribution to the reform of the Georgian legal system, but also in order to appreciate his cooperation and friendship with Ilyas State University faculty, both present and the future, we hope, would like to confer upon him the honorary doctorate of our university. So
I will give you the necessary
It's not so easy to become an author.
მადლობა ბრძანებისთვის.